Well, welcome everyone to our webinar on privacy law reform, how the proposed changes affect in-house counsel obligations. We firstly just want to apologise for the technical issues that the webinar provider had last week, and we're really glad that you've joined us today. So my name is Jess and my co-host is Phoebe, and we are senior lawyers in LegalVision's privacy and commercial law team. So before we begin, just a couple of housekeeping items. So you'll receive a copy of the recording and the slides in your email, so you don't have to frantically take notes. You can submit your questions in the chat box throughout the webinar and we'll answer them at the end. We've already received a number of questions, which is great. And there'll be a really brief survey for you to fill out at the end of the webinar, and we really appreciate your feedback. So you're eligible for a free consultation with LegalVision to learn how we can help your in-house team manage that really high volume business as usual legal tasks that you would undoubtedly receive on your desk. All you have to do is leave your contact details at the end of the webinar. So today we'll be discussing a number of things, really focusing on the key changes that we expect to see in the privacy space in 2024, including the changes to the meaning of personal information, new and clarified data retention requirements, new and improved privacy protections for individuals. I know we had some questions there about consumers. More stringent requirements for the collection and use of personal information, tighter timeframes for reporting data breaches, which we know is front of mind for many of you. And then we'll be giving you practical tips on what you actually need to do to prepare for these changes. So to start off with, Phoebe is going to give us some background to why these changes are happening and what we can expect.
Yeah, thanks, Jess. So, as you're all likely aware, following a series of high-profile data breaches in Australia, and to bring the law more into alignment with other more protective jurisdictions like the EU, the Australian government has decided to change privacy laws to better protect consumers. And so in February last year, the Attorney General's Department released a Privacy Act report, which proposed 188 further changes to the Privacy Act to achieve these goals. And in September last year, the Australian government agreed in principle to 38 of those 188. So the changes will likely be made to the privacy laws this year. And privacy and data protection is an issue that we frequently hear is at the forefront of in-house counsel concern. And cybersecurity leaders are advising that it's not a question of if your organisation will have a data breach, but when. So it's crucial to ensure you have the expertise to help your organisation navigate the compliance complexities and mitigate both the legal and operational risks to protect the reputation of the business. So the changes we'll talk about today affect businesses that are characterised as APP entities, but we recommend that all entities operate on the basis that they are considered an APP entity and comply with these regulations. We hope today to shed some light on the practical implications of the key proposed changes and how you as in-house counsel can stay on top of your obligations. Importantly, many of our suggestions are steps that your organisation can take now to ensure it's ready for the changes when they're enacted later in the year. We don't know exactly when these changes will take effect or in what form, as they still need to undergo parliamentary scrutiny, but it's highly likely they'll be in the rough form that we're talking about today. So Jess is going to jump into it now to speak about the changes to the scope of personal information.
Thanks. So yeah, many of us are probably familiar with the current definition of personal information in Australia. So that's information or an opinion about an identified individual or an individual who is reasonably identifiable, whether or not the information is true or not, and whether the information or opinion is recorded in a material form or not. So this wording about an individual will soon be more broad and will encompass information that relates to a person, whether or not the name of the person is known. A reasonably identified person will be expanded to include a person who can be distinguished or set apart from someone else. So what are the implications of this? What does that actually mean for us? I think the main thing is that this definition is going to capture a much broader range of individuals, and therefore a much wider range of, you'll be handling a much wider range of personal information. You'll have to think about minimizing data collection and about all of your data masking and aggregating and de-identification measures, and make all of those more robust. One of the questions we received before the webinar was, what are the changes to sensitive information? So the definition of sensitive information is likely to expand to include genomic information, which is information relating to a person's genes. And the definition will be expanded to clarify that sensitive information can actually be inferred from information that is not sensitive information. I think many of us take this approach at the moment, but we'll see that sort of clarified in legislation. And we also expect that there'll be additional OAIC guidance on this, which will be helpful. Personal information will also be expanded to include information that businesses collect digitally, so things like IP addresses and device identifiers. We've seen many advances in data analytics over the past few years, and this has meant that information collected from one large cohort is increasingly used to make inferences about other individuals, regardless of whether or not those individuals have consented to it or if they're even aware of it. So personal information is also going to be expanded to include information that is inferred or generated. And to shed more light on the expanded meaning of personal information, it's likely that the Privacy Act will actually include a non-exhaustive list. I think this will be a very long list to assist us to determine when information will be personal information and when an individual will be reasonably identifiable. So I think we can all look forward to that guidance in the Act itself and from the OIC. We also like to think about how these changes compare or stack up against other countries. So you might be familiar with the GDPR definition of personal data, the start of which is any information relating to an identified or identifiable natural person. So it certainly seems that our new definition will align more closely with the GDPR. Okay, so that's a lot of information. What are the action items? What are the steps we need to take? So it's going to be necessary to use the updated lists of what personal information actually means to guide updates to your current privacy practices. It's very likely that you're handling information that was previously not classified as personal information, but soon will be. And so if that is the case, you'll have to check that your use or disclosure of that information actually complies with the APPs. So if we're thinking about APP 6, we need to think about, does that use or disclosure of the information relate to the primary purpose for which it was collected? And then if you're planning to use or disclose it for a secondary purpose, would the individual reasonably expect the disclosure, or have you received consent to use or disclose for that purpose? Okay, I'll hand over to Phoebe, who's going to chat us through clarified data retention requirements.
Yeah, great. Thanks, Jess. So yeah, another one of the agreed changes is some clarification to the data retention requirements under APP 11. And currently, APP 11 requires an APP entity to take reasonable steps to protect information from misuse, interference, and loss, or from unauthorized access, modification, or disclosure. An APP entity must also currently destroy or de-identify personal information it no longer requires. And one of the recommendations of the Privacy Act review was greater clarity around what is considered reasonable. And the government has acknowledged that this has been a challenge, and I think you can see that with a lot of the recommendations we're going through today. In addition to the requirements becoming more stringent, we're also going to get more guidelines that are going to help us navigate them and implement them. So that's really helpful, and this is one of them, certainly. So the government has agreed that the OAIC should provide technical and organisational guidance to entities about what reasonable steps an entity should take to keep the information secure, or what reasonable steps should be taken to destroy or de-identify personal information. And the changes are also likely to require media organisations to comply with security and destruction organisations. So that's sort of a new thing that'll be introduced. There are also proposals to incentivise businesses to reduce how much personal information they collect and to swiftly remove information when it's no longer needed. And this is certainly in line with criticism that we've seen come out of recent data breaches in Australia. So I think every single data breach of recent times saw businesses being criticised for holding on to personal information for just way longer than they should have been. So one of those examples is Optus. They faced a lot of criticism for holding onto passport, driver's license, medical details for consumers for about 6 years, when many commentators argued that they only really had a right to hold on to things like name and contact information. So, even when it wasn't necessarily the law yet, we saw that the public and, experts in the field were still criticising companies for their possession and their use of that information. Another one is Latitude, who also were holding on to information for about 10 years without really a justification to do so. So a key action item that can come out of this, and it's something that every business can start doing now, is conducting a privacy audit to understand what kind of personal information is your business holding on to and for how long. Bearing in mind that some organisations will have other record-keeping requirements in addition to the Privacy Act, but it's a way to really just reduce the risk of exposure if a breach is to occur. So it's an important one. And there's also some new and improved protections for individuals under these changes. So Jessica can take you through those.
Yeah, thanks. And again, this relates to another question, what are the implications for consumers? So we'll touch on that here. So I think I'd say that many Australians actually believe that they have a right to have their personal information erased. It's definitely been a bit of a buzz phrase over the past few years. Currently, Australians have other rights, including the right to access the personal information a business holds about them, and the right to ensure incorrect information is corrected. However, we don't currently have the right to request that companies erase our data. The Privacy Act review report revealed that 90% of Australians believe they should have this right, so the right to have their information deleted. And the government has acknowledged this concern and agreed in principle to granting individuals greater transparency and control over their personal information, including the right to request an explanation of what personal information is held and what is being done with it, and challenge the information handling practices of a business. We expect to have the right to require an entity to delete or de-identify information, that's that important one, and then finally to request correction of online publications over which an entity has control. So I think if we do see this right to request erasure, this might also extend to circumstances where a business has collected personal information from a third party, in which case the business will also need to notify the third party of the erasure request. Again, so how does this compare to other countries? I think the AG, the Attorney General's Department, has been pretty explicit in their stating that the proposed rights for individuals are modelled on rights given to individuals under the GDPR. And we also know that individuals are given a broad range of rights under the California Consumer Privacy Act. So clearly inspiration has been drawn from the CCPA too. Again, action items, what do we need to do to actually prepare for this change? So in the same way that you should have a privacy officer or someone at your company tasked with responding to individuals' access and correction requests, you'll need to start preparing to be able to erase information when requested by individuals. And also what I said before about where you've disclosed information to a third party, you'll need to be able to request and keep track of those third parties so that you can request that they erase information as well. Phoebe is now going to talk us through the requirements for the collection and use of personal information.
Yeah, so this is another one that's going to change pretty significantly. So currently under APP3, businesses must not collect personal information unless it's reasonably necessary for running the business. So as such, businesses can make subjective decisions that the information they are collecting, using and disclosing is indeed reasonably necessary. So this wording is likely to change to a fair and reasonable test and move away from the reasonably necessary, which seems like a minor language change, but the implications are actually going to be pretty significant. So reframing this wording is going to force businesses to stand in the shoes of the individual and objectively assess whether the collection, use, or disclosure of personal information is fair and reasonable. And this is regardless of whether or not that person has agreed to use that information. So where previously we would rely on a consent to sort of make this assessment, that's no longer going to be a cure-all, which is, I think, going to be a real shift for lawyers who frequently use those. So something to consider, certainly. It's also likely that an additional requirement will be included to the effect that where an entity doesn't collect information directly from the individual, it collects it via a third party, it must take reasonable steps to satisfy itself that the information was originally collected from that individual in accordance with this APP3. So that's really going to just practically open the doors to quite a significant due diligence operation potentially, if we're really considering, where is the information coming to our business from, and are we really satisfied that these other parties that we've been working with are complying with this obligation. And when we consider sort of the recent breaches and case law, this is another one where pretty much every high-profile data breach in recent years attracted public scrutiny over this, and there was a lot of outcry saying, why was this information really collected in the first place, which is really the motivation for this shift. Because it's become clear that, even beyond the penalties that the regulator can impose for breaches, the public is really critical about this, and they themselves have shown a real power to, inflict reputational damage on the business if they think you're not doing the right thing. So again, another one we can kind of start doing now, even before it happens, best practice. So when we consider the action items for APP3 changing, you need to make sure that the business that you're working for currently has the right to collect certain information, but also start implementing processes to ensure that when you're receiving it from a third party, that they have lawfully collected it. And so we'll have to start having a think about how can we actually do that. Is it going to be that we're changing the contracts and the clauses that we have? Are we using a questionnaire? I think we'll see some sort of creative options there, but we're going to have to start thinking about how we can practically approach that. Yeah, so I'll hand over to Jess now for how the tighter timeframes for data breaches are going to change.
Yeah, so we know that this is a big concern for anyone in business. And so we thought it would be worthwhile spending a bit of time on this one. So it's definitely front of mind for the OAIC. They've identified that security of personal information is a top priority, and they're really going to focus their efforts on this, particularly where there's the greatest harm or greatest risk of harm to individuals. So we definitely expect their focus to be on businesses handling sensitive information, businesses undertaking really large-scale processing of personal information like big data analytics, or businesses with a large customer base. And anecdotally, we've seen that the greatest risk of harm has occurred where there are failures to take reasonable steps to protect personal information, and inappropriate data retention practices, as Phoebe's talked about previously. So holding on to information for longer than is necessary, and certainly holding on to information where it's not necessary at all. And also that risk of harm also stems from failure to comply with the pretty clear notifiable data breaches scheme. So we'll go through a brief refresher now of the notifiable data breaches scheme, because you are expected to have an established process in place to ensure that you have a good response to data breach. So a brief refresher. So that if a data breach does occur, you're going to need to conduct an assessment as soon as you've become aware of the breach, taking note of what's happened, who was involved, what personal information was involved, and sort of an initial assessment of the damage. You're going to need to take reasonable steps to ensure that this assessment is done within 30 days. And then you're going to have to assess whether serious harm is likely to the individuals involved and prepare a statement summarising what's happened. You'll need to notify, where it is serious harm, you'll need to notify the OAIC as soon as possible, and you'll also need to notify affected individuals if there is a risk of serious harm, or if it's not possible to notify every individual directly, you'll need to publish a statement letting people know about the breach. Once it's all wrapped up, you'll need to review the incident and take steps to prevent future breaches. And then keep detailed records about the breach and your response to the actions. And failure to follow this process can result in fines under the Privacy Act. So we're talking now about these tighter timeframes. So currently businesses have a fairly generous 30 days to assess whether a data breach must be reported to the Privacy Commissioner and reported to affected individuals. So we're going to probably see reforms to the way businesses must respond to data breaches. And the government has agreed in principle that businesses should notify the Privacy Commissioner as soon as possible and within 72 hours. So really shortening that time frame within 72 hours of becoming aware of the breach. You'll also need to notify individuals as soon as possible, and you'll need to swiftly take steps to reduce the impact of the breach on affected individuals. So we've definitely seen these sorts of timeframes overseas. The US, it does depend state by state. In many, it is 30 days. So Australia might be becoming more strict, but we know that this brings us into alignment with the EU, where the timeframe for reporting data breaches is 72 hours. In all of Australia's recent high-profile data breaches, there's been criticism over the amount of damage that can be done with user data by the time an entity is required to report the breach. It's such a big time frame at the moment. So there have been a couple of recent determinations made in the last couple of years. And the main takeaway from these is that entities should have a considered and up-to-date data breach response plan. And in both Datatex and Pacific Lutheran College, the entities in both of these instances didn't have a data breach response plan in place before the breach occurred. Internationally, we have also seen, though, that this 72-hour time frame is challenging to meet. So it's really important that you're prepared. In September 2018, British Airways suffered a data breach affecting around 500,000 customers, including and personal information and payment information was involved. And the company was ultimately fined £20 million a couple of years later for failing to report the breach adequately within the required time frame. So yeah, it's certainly a good idea to get prepared and have a good data breach response plan, as well as all these other measures that we've been talking about, like reducing the amount of personal information that you collect, not holding on to it for longer than is necessary, and then ensuring that your collection is in accordance, your collection and use and disclosure, I should say, is in accordance with the APPs. These are all really good sort of risk mitigation steps so that if and when a data breach happens, you can respond and the sort of level of risk is minimized. Okay, so we've been through a lot of information. Phoebe's going to sort of summarize all of this with some practical steps that you can take.
Yeah, thanks, Jess. And I think, this reiterates things we've been talking about throughout the presentation, but I think really use them as tools that we can do now and tools that LegalVison can help you with, and things that can hopefully make these changes less overwhelming and stressful, because if you're doing all of these, you're really protecting your business. So yeah, let's jump into it. So one of the first things we recommend doing sort of as soon as possible is an audit of your data and privacy processes. So have a look at the current information you collect and what those processes look like, how your business stores and uses and discloses and monitors personal information, and identify any obvious gaps in those processes so that we can implement policies and procedures to fill them. At the same time, it's important to check how compliant you are with the existing privacy obligations. So ensure your employees understand the correct procedures and implement training if required. The next thing we recommend doing is starting to plan. So determine what steps your business will need to take to comply with these changes. So in particular, identify what processes will be required to erase an individual's information if requested. And the next one we recommend doing is considering what you can proactively do from a public relations perspective to establish a positive relationship with the public, so that when, not if, a data breach occurs, you can minimise the reputational damage. And this is one that we've seen some of our sort of marketing, PR partners talk about. You know, it's so damaging when consumers, they first hear of your business when they find out something's gone wrong with their personal information. But if they have a brand associated with you, it can be much less damaging to make a statement like that. And the last thing we want to make sure everybody's got up to scratch is the privacy toolbox. So have you got an up-to-date compliant privacy collection notice and a privacy policy, as well as a data breach response plan, getting ready for the big shift from 30 days to 72 hours for using those? And do you have an internal privacy compliance handbook, or do you conduct annual staff training? Because it's one thing to have sort of executives at a high level understand these things, and then people on the ground have no knowledge of them. So these are really important, and something that we can certainly help you with as well. So yeah, please let us know what we can do to assist you, and hopefully we can all sort of be prepared for these changes together. All right, so that concludes the main part of our webinar, and you might find this publication useful, which is just a summary of the key data and privacy developments, which reiterates what we've sort of spoken about today, but in a short form if you want to. Sealing the Deal, in-house counsel guide to streamlining corporate transactions, which I believe is on the 4th of April at 11 a.m. So you can register for that now. And we're going to answer your questions shortly. So please submit them while I sort of take you through this. And just tell you a little bit about LegalVision's desk extension, which is something that can really help in-house counsel. So having spoken to hundreds of C-suite and in-house counsel, we understand that in-house lawyers are increasingly being pulled in many directions. They're required to provide input on business critical and strategic matters at an executive level, while also managing a high volume of business as usual matters. And of course, all managed within a tight budget and an even tighter labour market. So under desk extension, LegalVision can assist you with all of the business as usual legal needs, allowing you to cost effectively increase the bench depth and capability of your team, and to prioritise those business critical matters. So we can also offer desk extension support in more narrow legal areas to assist your business. For example, we could limit the service to just employment or corporate support if that's where you're missing the gap within your own business. Our desk extension lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. You might also be interested in our privacy compliance solution. So we can help audit your privacy practices, provide practical recommendations, train your staff on best privacy practices, and assist you with all those privacy needs like the toolbox we spoke about before. So if you'd like to learn more about how desk extension or our privacy compliance solution can help you, just provide your details when the survey appears at the end of the webinar. And now we'll answer some of your questions. So I might kick it off to you, Jess, if you can, and we'll see what's come through.
Okay. So the first one is, it would be helpful to understand practical examples of how your clients meet the privacy requirements, and in the alternate, how some clients have failed to do so, and also what other teams within a large business should be involved to assist in this process in addition to in-house counsel. So hopefully we've gone through a couple of steps that you should be taking to meet the privacy requirements. But something else that I thought would be worth mentioning is where we've assisted clients with running a privacy impact assessment before undertaking kind of complicated or lofty privacy projects. So things like where they're handling personal information in a new way, or a really large scale way, or they're starting to handle a lot of sensitive information. And so all of this comes back to this idea of privacy by design. So if you recall, or if you're aware of APP 11, that APP requires an approach where privacy compliance is designed into projects dealing with personal information from the start. Don't start your project and then at the end think about the privacy compliance. The report that we've spoken about today proposes that the OAIC guidance should really be developed, which articulates factors which indicate high privacy risk and gives examples of activities that will require a PIA, which I think will be very helpful because at the moment the wording is quite vague as to whether you need to run a PIA, but that's something to keep in mind. And to address the part of the question about what other teams should be involved, well, I think certainly your IT team should be involved. So they can be involved in data mapping exercises to work out what personal information you collect and where it's stored and which third parties you're working with, who has access to it. And this sort of data map or inventory can help you understand the data flows and ensure compliance with privacy laws. The IT team is often the first to know about security breaches, so they should be well across the process to follow if a data or security breach takes place. And I think we've also seen, certainly even internally at LegalVison, IT teams can really help to evaluate and vet third-party providers that you're using who will be handling your personal information. So really making sure that we're following that APP 11 guidance to take steps to protect personal information from misuse and unauthorized access. And I think that mostly answers that question, but really privacy is a matter for everyone, and so training should be given out to all employees on handling personal information correctly, not simple steps that employees can take to minimize risks of data breaches. So things like password protecting devices and not sort of having personal or sensitive information available where someone else can access it. So hopefully that answers that question. Is there a question you want to take, Phoebe?
Yeah, so I've had one come through that's saying, how do you toe the line between erasure requests and data retention obligations? Which I think is a really good question, and I think one that's on a lot of our minds. And I think the short answer is we're not really going to know how this operates until we see the draft legislation. But we're expecting that the right of erasure, they intend it to be quite strong. So we are expecting that it will trump other and sort of other obligations in other legislation. Like, for example, we know healthcare and similar industries have their own pretty stringent sort of data retention obligations. So when we're yet to see how that will interact, but we're expecting the right of erasure to be pretty strong and for it to override quite a bit. We are, part of these amendments that are coming through has been an absolute acknowledgement that the guidelines are kind of lacking at the moment. So I think one of the things that we're looking forward to, and I think will be helpful for answering this type of question, is we will be getting some more guidance on how we can toe the line. And I think at the moment it's a tricky balancing act where businesses aren't required to erase, so it's difficult to assess at the moment. But it will change once these come through, and we're looking forward to seeing more guidance on that. So we'll all keep an eye out for the draft legislation, and I'm sure you'll be hearing more from LegalVison when it does, because we're going to figure out what this is all going to look like. Yeah. All right. Have you got another one, Jess?
I do. It's quite similar, but I'll read it anyway because it's got a bit of a medical aspect. Can you please elaborate on requests to remove personal information, whether this will be allowed? Also, would you please advise re-medical information when hospitals and GPs refuse to release your medical results without appointment, etc., whether this is legal and if the reforms will affect this? Yeah, super good point, because this right to request erasure will need to be balanced with other legal obligations that businesses hold on to personal information and sensitive information. So there are certainly, we know in the medical industry, there are legal requirements to hold on to medical records, and that's governed by various state and territory legislation. You might be aware of the general principles that apply for holding onto medical records. So patient medical records need to be kept for a minimum of 7 years from the date of last, from when they were last edited or updated, or when the patient last attended. So that there's that sort of standard obligation, which is going to trump that right to erasure. And then also, if you're dealing with children, the records need to be kept for 25 years. Until the patient turns 25 years old. So we are really going to see this probable right to erasure be sort of, I guess, that is going to come into play, but it's also going to perhaps offer some, we're going to see some confusion, I think, when individuals have this right, but businesses also have the legal obligation to hold on to records for longer than that, whether that's just for standard regulatory needs, like in the medical space, or for another legal reason, for example, where a business is required to keep documents that are involved in court proceedings. So yeah, it's a good question. Specifically on that question about refusing to release medical results without appointment, I'm not sure of the answer to that one. Phoebe, you might be aware, but certainly we know that medical practices do have legal obligations to hold on to information, and so there may well be a sort of legal reason why they need to hold on to those records until an appointment has taken place.
Yeah, exactly. And I think sometimes it's a balancing of different type of content within those records, and yeah, just sort of internal policy can also sometimes be what that is. So yeah, if you have sort of really specific questions about that, definitely get in touch. We've got a really experienced MedReg team that can help with those type of queries. But it's interesting to see how it'll interact with the Privacy Act when these are two robust and separate pieces of legislation. We're keen to see how they clash into one another. And sort of on that, we've got another question about the timeline. What do we know? Do we know anything more about the timeline for the new reforms? And basically the short answer is all we know is 2024. So the only thing that's sort of been publicly said was in September last year when the report was released, and they said expect to see it in 2024. But since then there's been pretty much radio silence. So if anyone within our network has any insights, definitely let us know, because we're sort of keeping our eyes peeled for any clues. I think realistically these things take time. So, it's not going to be, within the next quarter even. It'll probably be later in the year. And that's why we should be sort of taking this time to get our house in order and preparing and doing all of these things that we've suggested. But they have said this year, so sooner rather than later.
Yeah, and we haven't seen any kind of draft legislation yet.
No.
That's just come through. No draft legislation, but I think that the guidance and the government response gives us a pretty good sense of what we're going to see.
Yes, yeah, and that's available. If you'd like to look at that now, you can access that, and it sort of says, when things are agreed in principle or when they're not, and it is quite helpful. Like this is how we can tell what's going to be coming, because it is quite detailed, even though we don't have the draft yet. We certainly have some strong signposts.
Yeah.
Okay. Now, I think we also had some questions that were submitted before, Jess. I think one of them was about, are we going to see controllers and processes definitions that are like similar to the EU? So I might leave that one to you.
Yeah, sure. So yes, I think we will start to see more of this concept or distinction between controllers and processes. If you're familiar with the GDPR, you would be very aware of that distinction. And one of the proposals which has been agreed in principle, I should say, is this introduction of this idea of controllers and processes. So for those not familiar, a controller is a business that decides what personal information to collect and how to handle it, whereas a processor handles that information or handles personal information on a controller's instructions. So in business and in all your dealings, your business will be either a controller or a processor with respect to each types of personal information, or I should say personal data is the GDPR term, that you collect and handle. So a classic example is a business which collects names and email addresses of customers. It chooses to collect those names and email addresses, and then therefore it's the controller. And then when it shares those details with a third party, say a marketing provider, and the business and the marketing provider sends marketing emails to those individuals, they're doing that on the controller's instructions. So the marketing provider in that instance is the processor, and so that's the distinction. And I think what we're going to see, what we've read that we'll see, is the introduction of this distinction between processors and controllers, particularly in the context of a data breach. So what is likely to happen is that only the controller, who's actually responsible for initially deciding what information to collect and what to do with it and who to share it with, they will be responsible for notifying individuals affected by a data breach. Processors will still be involved. They might need to help the controller comply with this obligation. They might need to prepare a statement on the breach, and they'll certainly need to take any actions that the controller requests of them in respect of that personal information. So yes, I do think we'll be seeing more about, we'll be hearing those phrases and those words a lot more.
Yeah.
Yeah. Okay.
I've got another one just saying, do we expect there to be a transition period to sort of change over for the new reforms? And the report has said yes, they do intend to include a transition period, and they'll sort of do I think they've called it an impact analysis at the time that the draft is first prepared. So there'll probably be more opportunities for the public and key stakeholders to weigh in on this. And certainly if you have thoughts or concerns about this, then stay engaged in it so that we can, have our say, because obviously, us as lawyers are likely to be the first line of defence impacted by this, and the ones that are going to need that transition period the most. So we'll be interested to see what that is, and there will be one. We just don't know how long.
Okay. I think that's all we have time for at this point. So we'll wrap up there today. I think we answered most, if not all, of the questions, but we'd love to keep chatting about this with you. So feel free to submit your details in the survey at the end for assistance with any questions that we didn't answer, or assistance with any elaboration on those questions. And then also we'd love to hear from you to chat more about how our desk extension membership can help you. And so, yeah, thanks for joining us. There will be that really brief survey at the end. We really appreciate your feedback because it is a free webinar, and so we like to know how we can improve. So that shouldn't take you long. As you can see on the screen there, you can leave your details to book in a call with our enterprise team. It's been great to chat through all of this with you today. Hopefully you have a few action items coming out of this webinar. And yeah, thanks again for joining us.
Thanks so much, everyone.